Welcome to another episode of Ask the Lawyer. This is the podcast where we tackle your legal questions no matter how big, small, or complicated they might be. As we always start, I am Evan Schwartz, the founder of the law firm Schwartz, Conroy, and Hack. I'm Matt Conroy, Evan's partner. And we always have to start with our little disclaimer, which I am going to read for you now. The information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Watching this podcast does not create an attorney-client relationship with any of the attorneys featured or the firm. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. And with that, we're going to get right to our questions.
What's the difference between a lawyer and an advocate?
So that's kind of a fun question. Matt has had a very interesting take on this, but being a lawyer is knowing how to understand the law and how to interpret the law and how to shape the law. But being an advocate is understanding what your client wants, what your client needs, and how to go about doing what you need to do within the bounds of the law and your ethical obligations to get that for your client. It's that simple.
So when I think about the question, you think about England and the common law system, Australia, Canada, where you actually have a licensing distinction between barristers and solicitors. Solicitors are what we would call lawyers under this question. They write contracts, they draft wills, they handle basic research and pleadings, they negotiate things on behalf of companies. But barristers are the ones who actually go to court and advocate for the client. And my view of this, and obviously this comes from the posture of a trial lawyer, is that a barrister and an advocate stand in the shoes of the client. You know, you are your client's representative, and you are speaking on behalf of that person. You are representing that person, and you are holding their interest in your hands. You present evidence, you present cases, you present arguments, and you ultimately, try to achieve the client's goals before whatever the tribunal might be. But it's literally a different license in the common law system in those three countries. And it requires different training, different courses, different examinations. And in the United States, we don't see it in New York in a lot of states, but there are states like New Jersey where you have trial lawyer certifications, where you have to take special steps to become licensed in order to go to court and to actually try a case before a jury. I think it's a minority of states that have those requirements, but I do think that in a bigger sense, you learn to be a lawyer in law school and in your early years of training and practice, but relating to a client, understanding their needs, and putting yourself between them and difficult things, be it the government or big companies or difficult, partnership disputes or spousal disputes. Those are acts of advocacy, and those take years to develop. They skills for.
They do. And understanding how to advocate for a client is how you understand what your client really wants. As I said, understanding what your client really wants, sometimes they just want the matter to be over and they've had enough. Sometimes you can do something and maybe get further along in the case, but it's going to be expensive and the client's not going to want to pay for it. So you have, there are different things that understanding what your client wants and going to get it for them in the correct way is how advocacy gets shaped. And I agree with Matt that it takes years to really go from being a lawyer to a lawyer who's an effective advocate.
Is it legal to record someone?
Matt?
So the simple answer is maybe. It depends where you are. It depends where they are. There are 38 states in the United States that are one-party states, meaning one party to the conversation has to consent to its recording. Obviously, more often than not, maybe all the time, that person is the one who's doing the recording. There are certain nuances to that rule where the one-party rule applies for certain states only when it's in person, and it doesn't apply to phone recordings. There are 11 states that are all-party states, or two-party states, as they call them in some forms, where both sides of a conversation have to consent specifically to the recording. Where we're situated in New York, it's pretty interesting. Between New York, New Jersey, Pennsylvania, and New England, they're split down the middle. So, Vermont, Connecticut, New York, Pennsylvania are one-party states. New Jersey, Rhode Island, Massachusetts, Maine are two-party states. So it begs the question, what happens when somebody from New Jersey calls someone from New York and the person from New Jersey records the conversation? That would implicate both states' laws. And so the question is which law applies? And there's a case in New York that essentially, it was kind of an interesting case. The caller was for lack of a better word, a lady of the night. Can we say that?
I think so.
Who called a famous person in New York, and the call was recorded in New Jersey, and the aggrieved person brought a lawsuit, including requests for injunctions to keep that recording from being published. And the New York courts held that even though the call was initiated from a one-party state, because the harm happened in New York is a two-party state. Actually, I have it backwards.
You have it backwards.
Because the harm was in New York,
Which is a one-party
which
state.
is a one-party state, that no consent was required because the lady of the night in New Jersey had consented to the recording because she's the one who made it. And so therefore it was not actionable. Had it been the reverse, where the two-party state, where the aggrieved person was in the two-party state, they would have applied the law of that state. And there are different cases across the country that sort of hold differently. California has a famous case, essentially, where they say, if the harm happened in California, our privacy laws trump, and therefore California law always applies. So whether the call happened in California or outside of California, if California law is implicated, you can go to California and they will enforce their own laws.
And obviously that's where one party is consenting and the aggrieved party decides they didn't want to consent because they don't like whatever was recorded. And in this world that we live in now, there's so much more recording. You go on video now, you go on to Zoom, or you go on to Teams, or you go on to some other, and unless you shut it off, it's automatically recording the entire conversation. And you need to be cognizant of that, because the rules around whether or not someone knew it was being recorded and consented to be recorded, all of that law is in development. But we're going to see where, privacy meets technology in a lot of these situations, and see how that shakes out. But the bottom line is, this is a creature of state law, and state laws vary. So you've got to know what party is in what state when it happens, and who's initiating and who's consenting.
Is it legal to break a lease early?
That's kind of a fun question. In the world of possession is 9/10 of the law, if you break a lease, typically you had an agreement. And the agreement was you were going to pay a certain amount of money, or you were going to receive a certain amount of money in exchange for someone either living on a premises somewhere, or having a piece of equipment, or a vehicle or something. You have an agreement. So if you decide to exit that agreement before the agreement has reached its conclusion, then it's probably illegal. Whether or somebody's going to do something about it is another question. And whether or not you had grounds or a reason to break the lease is also a factual question that someone's going to have to figure out. You know, if you were in an uninhabitable space and you leave, then you may have an argument that you didn't break the lease because you were constructively evicted. If you have a car that is not operable and might be a lemon and you stop making payments under that lease, you may have a basis to exit the lease, depending on the terms of the lease and the circumstances. So it's a very fact-driven circumstances situation in each case. But if you have an agreement and you're not honoring it, then you are subject to have broken the law, and that law is subject to being enforced by the person who is aggrieved.
Right. So with leases, this comes down to a matter of contracts. So you're contracting for, let's just say, commercial or residential real estate space. By simply leaving, you will be breaching that contract. What the landlord's rights and remedies are for that breach depend on a lot of things. One, there could be a liquidated damages provision in it where if you leave, it's difficult to ascertain what the landlord's damages are. We know what the rent is, we know what the expenses are, but the landlord is at that point under an obligation to re-rent the property to somebody else. They can take reasonable steps to market and show the property, to improve the property, but now you're getting into all these sort of specifics of, well, you should have done this and you should have done that. And if you have a liquidated damages clause, and you have this sort of difficult calculation, courts will enforce those and say, look, you agreed at the inception of this lease that if you broke the lease, it would be difficult for you and for the landlord to ascertain specifically what his damages are. Therefore, you're agreeing that the damages are X, and that's in the contract.
Right. I would just interrupt to say a residential lease, typically a landlord would have a duty to mitigate. A commercial lease, they might not. And then in that case, they can go after you for everything, and they don't have a duty to go out and re-rent the space.
Right. But the issue typically becomes, if you're in a position where you think you're going to breach, getting some good legal advice is probably not a bad idea. And the market conditions in which you find yourself are probably going to dictate what happens between you and that landlord. If you were in a waning market and you rented space at $25 a square foot, which is now renting at $15 a square foot, you are probably going to get sued. If it's vice versa, if you're in at 15, but they can rent it for 25 the next month, he's probably going to let you out of the lease. And that's usually, where these things end up.
And if you have a security deposit and you leave and don't pay the last month's rent, the lease may require you to pay the last month's rent. But from a practical perspective, the landlord's going to keep the security deposit. And as long as there isn't damages that they need to get from you, okay, you violated the lease, but no one really cares and no one's going to do anything about it.
And this is sort of a New York phenomena, but what you see in New York with most commercial leases is a good guy clause, where you basically have an agreement that you can get out early, and if you terminate early, you will owe 2 months of rent or 3 months of rent or whatever the number might be. And those are things that get negotiated prior to the inception of the lease.
Right. But just a reminder, leases aren't just for where you live. You sign agreements, like here in our office. Let's say our copy machine may be under a lease. You're leasing vehicles. You're leasing equipment. There are all types of leases in this world that, by violating the terms, if there's a writing, you have violated the law. What are the consequences of that just depends on so many other factors. So,
is it legal to use AI generated content?
All right. Well, that begs the second question. What are you using the AI generated content for? And my favorite thing is, as a lawyer, I always tell people, like a student, that if you use AI generated content for your schoolwork, in law school, in college, in high school, you're going to have a problem. And you're probably going to have consequences on the project. You may have consequences of even remaining as a student. But once you leave school, AI generated content as a lawyer can be your best friend if used properly, right? So that's just one example. Academia versus regular daily life. I can use AI generated content. I can use it for just about anything as a lawyer. And we do leverage AI as lawyers. AI is a great tool if used properly, right? So what are you using it for? As a lawyer, for example, and lawyers hear about this all the time. There's all this stuff going on where lawyers are submitting briefs to courts, citing cases that don't stand for what they're citing them for, and they didn't read the cases, they didn't really look at them, and judges are sanctioning these lawyers for doing this, right? So was it wrong to use AI generated content? No. Was it wrong to not check and verify the accuracy of the AI generated content? Yes, right? So what are you using the AI generated content for? In so doing, are you creating a problem for yourself or your business when you do that? And I'll let you elucidate a little further on that.
Yeah. So on the first part, when it relates to sort of academics or publishing material, the issue is plagiarism, right? And when prior to the world of AI, when we would undertake a task of writing something authoritative, we are using our own thoughts, our own words, and then using historical information that we cite to other people's thoughts, other people's works, other people's words, so that we're giving credit to the people who actually wrote these things. And that is the line between plagiarism and non-plagiarism. AI goes out on its own and solicits information from the universe, from all these different sources, and consolidates it into a work that has no citations more often than not. Legal AI is a little bit different, but when you're asking AI a question or a series of questions or putting in parameters and it's spitting back all this information, you are getting a collective group of plagiarized thoughts and ideas. They're taking it from other people without necessarily giving credit for it. When you take that and you use it yourself, it is a form of plagiarism. It's become an acceptable form of plagiarism in certain venues, but when it comes to school, there's now AI within AI in order to check whether or not work is your own. So I look at AI and I think that, I like to use it to source issue spotting and concepts and ideas. And then I use those to make outlines, and then I write my own thesis or thoughts, or arguments off of the series of bullet points that I might get from AI. It's a starting point. And, hypothetically, I don't do it, but I could, I suppose, use it as an editing tool where it's basically checking my syntax, grammar, sentence structure, paragraph structure, flow of arguments, things like that. But when you're using it for both, it's pretty hard to weed out, your thoughts from its thoughts. And to say that something is your work versus its work, those are tricky things. In the world of legal AI, the prior to the Lexis and Nexuses of the world and having closed systems where all of the information is being drawn from, case law, statutes, or, primary sources of legal information, you had chat and these other systems that were going out into the universe to find propositions that satisfied the user's question. And they would fill in gaps with completely fake citations that looked like real cases. And so Lexis and Nexus's solution to this was, let's create a closed system where it can't do that, or it won't do that. And as much as, we're thrilled to see that happen, in our own world, we see, multiple instances where briefs come through where AI was used, and you have a cite, a quote that's cited, and when we go and look at the cite, that quote doesn't exist within that cite. And on multiple occasions, I've found that, that cite might refer to a trial court decision from a federal district court or from a Supreme Court judge. And then that decision or order
from that original trial court case was appealed to the Second Circuit or to the Second Appellate Division. And the cite actually came from the appellate case, not from the case that it cited. So the case name is right, but the cite is wrong because it's the wrong court for that case.
So,
and a court, a court or an adversary isn't going to go through the trouble of trying to figure that out. They're just going to say, we looked at your cite, we looked at the string cite, we checked the case. It doesn't say that.
Right.
What say you?
Well, what I say is, that's lawyer stuff. But AI does so many different things, and there are so many different things where you could try to pawn things off on your own work and put yourself at risk for someone saying you're basically copying my stuff. It's happening in the music industry. It's going to happen, obviously, in the literary industry. It's going to happen in the art and photography industry. And so it's not, the general concept is using AI illegal? No, but what are you using it for? So
what's the difference between a felony and a misdemeanor?
Matthew.
So it's a little bit different from state to state in New York. Essentially, a misdemeanor is a lesser crime that you can be prosecuted for. Misdemeanors are typically, your sentence is going to be in a county jail, and it's going to be for less than a year. Felonies are, aggravated assault cases, murder, grand larceny, major crimes for which you can be punished for more than a year, and you serve your sentence in a state prison.
There's also a dollar value associated with a crime. I believe in New York, I don't know if it's changed, but I thought it was over $1,000.
On larceny?
Yeah, on larceny.
Well, I think that's the difference between petty larceny and grand larceny.
Which is the difference between a misdemeanor and a felony.
And you've got different classes of crimes. There are essentially 5 classes for felonies and 2 for misdemeanors, A and B, and A through E. In other states, there's a little, different scales. Massachusetts, for example, misdemeanors can be up to, I believe it's 3 years in a county house of corrections. And the statutes are specific. Each criminal statute has the actual penalty in it, and it will say, subject to being sentenced to up to X years, either in a county house of corrections or in a state penitentiary. Obviously, the felonies go to the state penitentiaries, and the misdemeanors go to the county facilities. Not always what you would expect the result to be. Sometimes the jails in the House of Corrections where you're sentenced for a misdemeanor are the same places where all of the people who have been charged with felonies who are held without bail are also housed in those facilities. So being convicted of a misdemeanor or pleading to a misdemeanor and doing county time in a jail, it's not a cakewalk, so to speak.
Right, and there's consequences for the felony, which is obviously the greater crime than misdemeanors in how you're affected as a citizen.
Voting rights, gun rights.
Correct. And in New York, for example, if you're a lawyer, you're convicted of a felony, it's grounds for automatic disbarment, regardless of whether it was a crime of passion or a crime that might be sort of a financial crime or a crime of moral turpitude, as they like to say. Because lawyers, a lawyer can have a DWI, or a lawyer can have an assault where they did something bad, but it wasn't deemed to be something where their trust as a lawyer by a client would be compromised, because it's not sort of a financial crime or a crime of perjury or something where they can no longer be trusted as an advocate.
He was
right?
looking at me funny.
Right. So the bar brawl is not what's going to get you disbarred, as they say. So you can have the brawl in the bar as long as you don't really hurt someone really bad. Why not?
But stealing your next door neighbor's flat screen TV from their backyard probably will.
Is a problem, correct. So felonies versus misdemeanors. Obviously, misdemeanors, less serious crimes, easier to plea bargain in most states, maybe plea bargain them down to something that's not a crime. That's also going to depend on whether you have prior criminal convictions and whether the seriousness of the crime itself and a number of other mitigating factors. But that's the basic difference.
Thank you for joining us. Hope to see you on the next one, which will be coming very soon. And just a reminder on the disclaimer one more time. The information provided on this podcast is for entertainment purposes only and does not constitute legal advice. Please consult with a licensed attorney in your jurisdiction regarding any legal matter you may have. Watching this podcast does not establish an attorney-client relationship with any of the attorneys featured. Take care, everybody.